Hi there. Welcome to the webinar for Replica Analytics on how private is synthetic data. My name is Richard Hoptroff, one of the board members of the company, and I'll be comparing today. And to tell you a bit about the company, our focus is to understand exactly how to generate synthetic data as a way of creating data that can be safely used without exposing the privacy concerns of individuals. What this entails is basically analyzing real data to understand the underlying dynamics of that data, and then using that to randomly generate new data samples which are completely unrelated to the original data set in terms of identifiability. Now, that's the purpose of what we're trying to achieve. That's the purpose of what we're trying to achieve. And the topic here today is exactly the legal aspects of that. So how is the idea of data privacy interpreted amongst different legislations with different legal practices? So today we have speaking. First we have Lucy Mosquera, who's going to explain the disclosure principles and what synthesis protects against. And then Mike Hintz is going to review how that actually applies to different regulatory spheres, including GDPR, CCPA and HIPAA, and try and understand exactly what might be interpreted amongst those regulations, because obviously when you have regulations, they don't tell you what to do, they just tell you vaguely what should be good practice. And that needs to be interpreted by the industry so that we all know what is acceptable practice. And then finally, Lucy will go on to explain some of the examples of privacy assurance that Replica Analytics has been engaged in. So at that point, I would like to hand over to Lucy. If you could please make a start on telling us about the risks that we might need to be concerned about.
Yeah, of course. Thank you very much, Richard, for introducing me and getting us started. So as Richard mentioned, I'm Lucy Mosquera. I'm the lead statistician here at Replica Analytics. So Replica Analytics generates synthetic data for the health field and beyond, as well as providing utility and privacy assessments for synthetic data. So this talk will be focused on how to assess privacy risks in structured, fully synthetic data. So by structured data, I mean data housed in databases, so not images or free-form text or speech or recordings or anything like that. And by fully synthetic data, I mean a synthetic data set that has been generated in its entirety from a model of a real data set. So this means there are no real observations or variables. So just trying to distinguish fully synthetic data from partially synthetic data. Partially synthetic data is where you have a mix of some real and some synthetic, either variables or observations. So this talk is going to be, again, focusing on privacy risks in structured, fully synthetic data. So just for a little bit of context, high-level synthetic data is data that is generated from real data, but is not real data. It has the same statistical properties as the real data set used to generate it, but it is not real data. So there's this perception in the community that synthetic data has no privacy concerns and that we can share it freely without having to worry about privacy risks. However, this isn't entirely true. Synthetic data is generated from a model fit to a real data set. This means that if the model fits the real data too closely, the synthetic data may recreate the real data exactly, leading to the same privacy concerns present with sharing the original real data set. So the use of synthetic data doesn't inherently guarantee privacy. Additionally, Even if a model does not overfit the real data, we have seen that the legal team or privacy officers at organizations are interested in quantifying the privacy risks for synthetic data. This includes defining and measuring privacy risks in synthetic data. This quantification of risk is essential for adopting synthetic data as safe to use. The privacy assurance methods that I'll be describing in the second segment of my talk are key to building this trust. This first section will focus on defining privacy risks associated with synthetic data. So some of these risks are mitigated via synthetic data, whereas others may require additional controls. So in our discussions of the privacy risks regarding synthetic data, it's important that we are precise and clarify definitions about what types of privacy risks are managed by using synthetic data. So let's get started with some definitions and examples to illustrate these definitions. So first off, identity disclosure is assigning a real person's identity to a record in a synthetic dataset. If you're able to do this with a dataset, then an identity disclosure has occurred. So in this example dataset, if a person or adversary was trying to identify records in the data, they might be trying to figure out which record belongs to Hiroshi. So if the individual or adversary, for the individual or adversary to have a chance of doing this, they must already know some information about Hiroshi. So in this example, let's assume that our adversary knows that, firstly, Hiroshi is in the dataset, and secondly, Hiroshi is Japanese. So in this example, if the table on the slide is the complete dataset, our adversary is able to identify Hiroshi as the first record in the table. So in this situation, the adversary is able to learn Hiroshi's income and is able to exactly identify which record belongs to Hiroshi. And so because the adversary is able to identify which record belongs to Hiroshi, an identity disclosure has occurred. Similarly, the next privacy risk that we'd like to define is attribute disclosure. So in this example, our adversary again knows that Hiroshi is in the data and that Hiroshi was born in 1950 to 1959. So our adversary can then deduce or learn that Hiroshi has prostate cancer. So how is our adversary able to do this? Well, all males in this dataset who were born between 1950 and 1959 have a diagnosis of prostate cancer. So with 100% certainty, the adversary has learned that Hiroshi has prostate cancer. This example illustrates when an adversary has learned something about the group of people Hiroshi belongs to without identifying which specific record is Hiroshi. This kind of attribute disclosure is the root of data analysis, as it allows us to understand groups' attributes. The next type of risk that I'd like to define is inferential disclosure. This dataset is very similar to the previous example, and the adversary knows the same information about Hiroshi. So the adversary knows Hiroshi is in the dataset, and that Hiroshi was born between 1950 and 1959. But now, the adversary can only learn that Hiroshi may have prostate cancer with 50% certainty, as among the two records that meet the criteria of, or among the four records that meet the criteria of being male and born between 1950 and 1959, only two of the four records have a diagnosis of prostate cancer. So in contrast to the previous example, where we learned an attribute with 100% certainty, with inferential disclosure, what we learn about Hiroshi or the group that Hiroshi is a part of is uncertain. So our final example of this stage, we have another data set with three variables. In this situation, let's assume our adversary knows Hiroshi is in the data set, knows Hiroshi was born in 1959, and knows that Hiroshi is male and has an income of 120K. Then the adversary is able to identify that Hiroshi is the first record in the data. However, the adversary has had to use all of their information that they know about Hiroshi to make this identification. So Even though the correct record has been identified for Hiroshi, the adversary has not been able to learn something new about Hiroshi. So these examples highlight the three key types of privacy risks in synthetic data: matching identities to individual records or identity disclosures, learning an additional characteristic based on a group of records with certainty, which we call attribute disclosure, and learning an additional characteristic based on a group of records with some degree of uncertainty, which we're distinguishing from attribute disclosure as inferential disclosure. When considering managing these risks, we want to focus on quantifying and managing the risk of learning something new about individuals. Learning something new about groups is the essence of statistics and data analysis, so managing this risk is less of a priority. Learning the characteristics or behaviors of groups is the purpose of data analysis, so we want to instead focus on the risks associated with learning something new about individuals. So to illustrate why we don't particularly want to focus on learning about groups, let's consider what it means to learn something new about a group. If you learn something new about a group, the conclusions we draw about that group may apply to individuals who are not in the dataset. So if Satoshi is in the same age and gender group as Hiroshi, we may learn that his risk of being diagnosed with prostate cancer based on the analysis of our initial dataset. If we aim to restrict the ability of learning something new about groups, or attribute disclosure, it limits our ability to draw conclusions about members of the group not in the data. This is a huge prohibition, as it inhibits gaining meaningful insights from our data, which is a huge concern in terms of utility. These kinds of risks of learning something new about groups can be managed in other ways, such as ethics reviews. Ethics reviews ensures that the conclusions drawn from groups are not stigmatizing or discriminatory, and that these conclusions will not be used for harm. So synthetic data does not directly address the privacy risks of learning something new about groups, but that is by design. What synthetic data is able to control for in terms of risks is managing the risk of learning something new about individuals. For synthetic data, you can learn something new about an individual if you are able to both assign an identity to a record and learn something new about that individual. When you learn something new about a record, it can be something usual or unusual. So let's try and illustrate this. In this plot, we have incomes for the United States. The specific values, I know they're a little bit hard to read, but they aren't important in this example. So let's consider if you were to learn the income of the individual marked with the red X. This income that we have learned is very common. It's actually probably the most common income in the data set. So learning that an individual has a very common or expected income is less insightful. In contrast, if we were to learn the income of this individual marked with the red X, this is a very unusual value. And it's an unusual value because it's not common in the United States. It's a higher income than usual. It's very far away from the average income for the country. So in this case, our adversary has learned something unexpected about the individual, which we can argue is a more meaningful thing to learn. So this leads us to our final definition of this section, meaningful identity disclosure. Meaningful identity disclosure occurs when we are able to assign an identity to a specific record and we are able to learn something new and unusual about that specific record. So if an adversary were to access this dataset looking for Hiroshi, and the adversary knows that Hiroshi is male and was born in 1950 to 1959, the adversary is able to identify that Hiroshi is the first record, and the adversary is able to learn that Hiroshi's salary is $250K, which is much higher than the other individuals present in the dataset. we would consider this a meaningful disclosure, as the adversary has been able to identify Hiroshi in the data and has been able to learn something meaningful about Hiroshi in the process. So this is a meaningful identity disclosure. So things that we would not consider meaningful identity disclosures include not being able to assign an identity to a record, not being able to learn something new, or learning something new about a group of individuals without being able to know which record belongs to the target. So these are not privacy risks that are managed with synthesis. So to reiterate, with synthetic data, the main way we quantify risk is via meaningful identity disclosure, which is the ability to correctly assign an identity to a record and then learn something new about that individual that is unexpected. So the assessment of meaningful identity disclosure is the focus of our methodology and presentation today. Attribute disclosure, or learning something new about a group and the potential for harm associated with that, is orthogonal to data synthesis. These orthogonal risks can be managed by ethics oversight, which is something that many leading companies are starting to implement to manage these risks. As learning something new about groups is the essence of data analysis, this is not something that data synthesis mitigates and will not be the focus of our talk. So hopefully all of these definitions and examples are clear and have gotten you all in the headspace of thinking about privacy risks for synthetic data. So I'll be passing things over to Mike, who will be discussing how synthetic data fits into current regulations from a legal perspective.
Great, thank you, Lucy. My name is Mike Hensey. I am a partner at a law firm based in Seattle, and I teach privacy law at the University of Washington School of Law. I'm also a senior fellow with the Future Privacy Forum. And today I will be talking about how synthetic data interacts with a variety of privacy laws. I know not everybody on the call today is an attorney, so I will take that into account and try to provide a little bit of background and then focus on a few key privacy laws and how the creation, evaluation, and use of synthetic data may be impacted by those laws. So I think we're all aware that there have been general trends globally in privacy law towards more laws being adopted, increasingly onerous requirements of those laws, existing laws being interpreted more strictly, or new regulations being adopted under those laws, or new regulatory guidance, where the clear trajectory is towards stronger privacy protections, more regulation of data, more restrictions on how data can be used. At the same time, trends in business, in science, etc., have been towards relying more on uses of data, and those two trends are increasingly coming into conflict, where productive and useful data, uses of data, are becoming more difficult, costly, and risky. Some of those privacy laws that we're seeing develop, and I'll talk about this a little bit more later, have tried to build in some flexibility to allow for productive uses of data, particularly around research and science in the public interest. But often the exceptions or other provisions that are built into these laws are quite narrow or vague, and have not proven to be as useful as some would hope. So synthetic data is clearly, as Lucy described, a very interesting approach that offers enormous promise for making data useful while addressing the privacy concerns that these privacy laws are designed to address. As we go through this today, I'm going to focus on three key questions under the three privacy laws that I will address specifically. The first is, because the development, the creation of synthetic data starts with a real data set that includes personal data. We need to ask, how is the use of that real data to generate and then subsequently evaluate and conduct the privacy assurance evaluation that Lucy mentioned? How is that use of the real data set regulated? How is the use of that data set that contains personal data to develop and generate synthetic data sets regulated by these privacy laws? Is it allowed? What kind of restrictions are in place? The second question we'll look at is, because most organizations, companies, other organizations won't have the expertise or capability to generate synthetic data in-house, they will often be wanting to use a vendor to develop synthetic data for them. And that inherently involves sharing that real data set that we start with that contains personal data with a third-party service provider. So how is that sharing regulated under these laws? Is that permitted? What kind of restrictions are in place? And then finally, the third question that we'll look at is, once a synthetic data set has been developed, and for the purposes of this talk, we're talking about a fully synthesized data set where all records and variables are synthesized, as opposed to other partial or hybrid models where only some of the records or some of the variables are synthesized. We're talking about fully synthesized data here. Does the law continue to regulate those fully synthesized data sets? So the first law we'll talk about is the GDPR, the European General Data Protection Regulation, that came into effect May of last year. And the first question is the use of a real data set to generate or evaluate synthetic data restricted or regulated under the law? And the answer is yes, it is. Under the GDPR, any processing of personal data is regulated. And personal data is defined quite broadly, as we'll talk about in a minute, and we'll assume for the purpose of this discussion that the original data set that's used to generate the synthetic data set is, in fact, personal data. And so it is regulated by the GDPR. Any processing, and processing is another term that's defined quite broadly, any use of that data, any analysis of that data, really anything that touches that data is considered processing. Under the GDPR, that requires a legal basis. The GDPR requires that any processing of data is based on one or potentially more legal bases that are set out in the law. The most common one that people understand is consent. The end user, the data subject, the person about whom the data relates, has consented to the use of that data. But there are many circumstances where consent is either impractical or in some cases even impossible to get in a meaningful way. And there are other legal bases recognizing that challenge with consent. There are other legal bases under the GDPR. The most commonly used one outside of consent is what's known as legitimate interests. It is a legal basis that involves a balancing test. You need to evaluate the legitimate interests of the data controller, the owner or the entity that is controlling the data, the legitimate interests of them or a third party in processing the data versus the risks to the rights and freedoms of the data subject. So when we look at a legitimate interest balancing test, each case needs to be looked at its own. It's a very fact-based determination. You need to look at the facts of the particular case. But to generalize just a bit here for the purposes of this discussion, when we look at the development of synthetic data, oftentimes the interests of the the interest of the data controller will be quite strong. There'll be a strong interest in wanting to develop a synthetic data set so that they can achieve value from this data, develop new insights, etc., in a way that protects privacy, it's sort of the best of both worlds for them. It allows them to develop this synthetic data set, which they can then use subsequently to extract value and develop new insights and new understandings and unlock new knowledge, while not threatening the privacy of individual data subjects. So that can be a very strong interest. On the other side, the risks to the rights and freedoms of the data subject, assuming that the development, creation, and evaluation of the synthetic data is done in a secure environment, it's not exposing the real data set to unauthorized uses or disclosures, that it's protected appropriately. The risks to the data subject are quite low or really negligible. And in fact, the data subject might have a strong interest themselves in the development of synthetic data, so that uses of that synthetic data, which might otherwise have been done on real data sets, will be done in a way that protects their privacy. So in most cases, and again, this has to be a fact-based determination on a case-by-case basis, but in most cases, it seems pretty clear that there's going to be a strong case for relying on legitimate interests as a legal basis under the GDPR for the creation and evaluation of a synthetic data set. Beyond the principle of a legal basis under the GDPR, there are, of course, other obligations on organizations that are processing data. And again, that we're starting with a real data set that's personal data. And so the obligations around data security, which I already alluded to, the obligations around transparency, all the other obligations under the GDPR will apply to that real data set. But in the case of developing synthetic data, that shouldn't be a significant additional burden on these companies, because these are obligations that these companies will have anyway, because they already have that real data set. So they already have an obligation to keep it secure and make sure that it's secure. They already have an obligation to be transparent about how it's used. So in drafting their notices, maybe they'll want to add another line in there about how it might be used to generate non-personal data that can subsequently be used for analysis or research. So all of these things, while there might be a marginal additional step companies may need to take when contemplating an additional use of this, i.e. to develop synthetic data, they're not significantly new obligations that these companies will be facing. So all in all, the bottom line here is that yes, the GDPR does regulate that use of the real data set to generate synthetic data, but there's a path forward. There's a path forward with legal basis, strong case for legitimate interest as the legal basis, and the other obligations are things that the companies should be already doing, and there may be merely marginal additions to that. Looking at the net data with a service provider to generate the synthetic data set, under the GDPR, there's the concept of a data controller, and that's typically the company that owns or controls the original data set. And there's a principle of data processor, and that's usually a service provider that's performing a service to the data controller that involves a need for them to process the data on the service, on the data controller's behalf. So under the GDPR, a data controller can share personal data with a data processor as necessary to enable the processor to perform that service. But there are certain obligations on both the controller and the processor in those scenarios. The controller has a duty of care to select a data processor that can provide sufficient assurances regarding the protection of the data. And there needs to be a contract in place reflecting what those guarantees are between the controller and the processor. And that contract has to have specific things in it that are set out by the GDPR. That contract needs to state that the processor can only process the data for the purpose for which it's been given it to perform that service on the documented instructions of the controller. The processor needs to have reasonable security procedures and practices in place. They need to ensure that each person who's working for that processor is under a duty of confidentiality with respect to the data. If that processor is engaging a sub-processor, another service provider that may be touching the data, they need to pass through those contractual requirements around protecting the data, and they need to have either a general or specific consent of the controller to use a sub-processor. It's another one of the obligations that are set out. The processor needs to assist the controller with meeting the controller's obligations. So with respect to data subjects exercising their rights to access or delete the data, with regard to data security, notification of data breaches, risk assessments, etc. To the extent that the processing that's being done by the processor implicates one of those obligations of the controller, the processor has an obligation to assist the controller with meeting those obligations. The processor needs to delete or return all the personal data at the completion of the service. And the processor needs to provide to the controller upon request information necessary to demonstrate the processor's own compliance with these obligations and to permit audits by the controller if the controller so chooses to exercise that right. So there's a number of things that need to be set out in the agreements, and these are not unique to synthetic data by any means. These are things that apply to any service provider relationship where a data controller is engaging a data processor, whether that's for customer support, for evaluating security of systems. There's any number of types of service providers that fall into this kind of arrangement. And so the service providers that are generating synthetic data would really be no different under the GDPR. They would just need to be sure, the controllers and the data processors would need to be sure that these protections, these contractual assurances are in place. So again, definitely regulated, but there's a clear path forward to enable that. The big question, the synthetic data. Now that a fully synthetic data set has been created, is it subject to the GDPR at all? Is it regulated or affected by the GDPR? The GDPR, like other privacy laws, is scoped to some definition of the type of data that it covers. The term used under the GDPR is personal data. It's defined quite broadly under the GDPR as any information relating to an identified or an identifiable natural person. An identifiable natural person, and it goes on to talk about the kinds of identifiers that can be used to identify. It's a broad scope. In past years, there's been a lot of discussion around the concepts of de-identification. What can you do to the data to de-identify it, to get it outside of the scope of the GDPR? And the regulators in Europe have set a very, very high bar for that. It's very challenging to achieve what would be called a fully anonymous data set through traditional de-identification. And traditional de-identification involves usually masking or deleting or obscuring in some way some of the elements of the record, the direct or indirect identifiers. But synthetic data, as we heard, is something different. It's not de-identification. It's not taking a record in a data set and doing something to it to obscure it, because in a de-identified data set, there is a relationship between the de-identified record and the original record. In a synthetic data set, it's not real data related to real individuals. At the aggregate level, there's a statistical relationship between the original data set and the synthetic data set, but there's not a direct link between records in the two data sets. So the records in a synthetic data set do not relate to an identified or identifiable natural person, and it does not reference the physical, physiological, genetic, mental, economic, cultural, social identity, etc. from the definition of the GDPR personal data term. It does not reference those elements of an actual natural person. So there's a strong case to be made here that a synthetic data set is not personal data under the GDPR. It's fairly well accepted that aggregate data about groups is not personal data. It really has to be data about an identified or identifiable individual. And so, as I said, there's a strong case to be made that the GDPR simply does not apply to a fully synthetic data set that has been created and evaluated to ensure, as Lucy mentioned, that there's no significant risk of identity disclosure. So let's move on to the next law. Last year, all the talk was about GDPR because it came into effect in May of 2018. This year, there's a lot of focus on the CCPA, the California Consumer Privacy Act, which is coming into effect in less than a month on January 1st, 2020. This is a new law, so people are still trying to figure out what it means. There's a lot of uncertainty and confusion around certain elements of the law. But I think for our purposes, the questions that we are answering, there is at least a reasonable level of certainty about what those provisions will mean. So the first question is the use of an original data set that contains personal data, or under the CCPA, the term that's used is personal information. Is the use of that data set to generate or evaluate a synthetic data set restricted or regulated under the law? Unlike the GDPR, the CCPA does not have this lawful basis principle. So there's no obligation to articulate a basis for processing data. And in fact, most internal processing of data by a company is unregulated by CCPA. There's some obligations around transparency, as there is in GDPR, but the question of whether or not you can do it, CCPA simply doesn't speak to that. CCPA is mostly focused on sales of personal data from one company to another, sales to a third party. And sales is defined quite broadly, as we'll talk about in a moment when we're talking about service providers. But internal uses and uses that are done by service providers are generally allowed. There's not significant restriction on that. So CCPA clearly allows internal uses of data to generate synthetic data. There would be no aspect of the CCPA that would prohibit that or put additional restrictions on that other than the need to be transparent in the privacy notice. There are other obligations, as I mentioned, so transparency, etc. But again, as in the GDPR, those kinds of obligations are things the companies have to do anyway, and at most it's a marginal addition to those obligations. For example, with notice, adding another line or a few words to the privacy notice that contemplates or encompasses this type of use of the data. So getting into the sharing part, sharing the data with a third-party service provider to generate the synthetic data. As I mentioned, the CCPA does regulate what it calls sales of data. And I put sale in quotes because as it's defined under CCPA, it's much broader than what we might traditionally think of as a sale of data, where data is transferred and money is transferred back. The concept of sale encompasses anything where data is transferred and the entity that's transferring the data receives something of value in return. It could be IP rights, it could be it could be any number of things, but that the very broad definition of sale. But there is an exception for service providers, transfers to service providers, and they're allowed from the restrictions on sales if certain conditions are met. A transfer to a service provider can proceed without it being considered a sale, without triggering all the obligations on a sale, including an obligation to allow the individuals to opt out. It can proceed if the service provider, or if the business has provided notice that the personal information will be shared with service providers. Most privacy notices today have language that conveys that data may be shared with vendors or service providers or data processors. So that's not a significant new requirement. that the service provider does not collect, use, sell, or disclose personal information for any purpose other than as necessary to provide the services on behalf of the business. That's very similar to what we saw under the GDPR with the contractual requirement that the data not be used beyond the instructions of the data controller. And that there's a written contract, again, very similar to the GDPR, between the business and the service provider that specifies that the service provider is prohibited from retaining, using, selling, or disclosing the personal information for any purpose other than performing the services specified in the contract. So again, also quite similar to the GDPR. Some have interpreted this language that says that if there's a GDPR compliant contract in place with the service provider, you're already good to go with respect to CCPA, service provider provisions, and that you would fall within that exception to sales because it would be a compliant service provider. Others have said, well, we should tweak the contractual language a little bit to make sure that the CCPA-like language is in there as well. But regardless, these are, again, a path forward for allowing those kinds of transfers as there is under the GDPR. Okay. So the question of whether or not the fully synthetic data set at the end of the day, after it's been developed and evaluated, is subject to the CCPA. Can it be further used? Could it even be sold, which is highly regulated by the CCPA, without restriction? And the answer here is similar to under the GDPR. The CCPA also has quite a broad definition of personal information. Any information that identifies, relates to, describes, or is reasonably capable of being associated with, or could be reasonably linked directly or indirectly with a particular consumer or household. The household piece here is interesting because that actually is a group, and as Lucy talked about, typically, and I mentioned earlier, typically privacy law isn't focused on information about groups. Here there is an exception with a very specific and typically very, very small group. If it's information related to a household, it will be covered. This definition should not capture a fully synthetic data set. Again, they are not data about real consumers or households. They've been generated from real data, but the resulting data is not data about real consumers or households. The CCPA definition specifies that it doesn't include aggregate consumer information, which is information that relates to a group. Household is the exception, but information that relates to a group or a category of consumers. If the individual identities have been removed, and that's exactly what a synthetic data set is. It's effectively information about a group with no identities, no real individuals in that. So again, here there's a very strong case that it's not subject to the CCPA once a fully synthetic data set has been created. Okay, let's jump over to HIPAA and we'll talk about that for a couple of minutes. Under HIPAA, the information that's regulated is called protected health information, or PHI, and many uses of it require individual authorization, effectively consent of the patient in the medical context. But there are some exceptions. One exception is for the use and disclosure to create de-identified information. As we talked about, synthetic data is not necessarily de-identified information in the traditional sense of that word, but as HIPAA refers to it in this exception, one of the exempted uses is to create information that is not individually identifiable health information, which is exactly what the creation of synthetic data does. So it very likely would be interpreted to fall within that exception. There's another exception that somewhat overlaps. It's for healthcare operations, which includes general administrative activities of the entity, including but not limited to creating de-identified health information or a limited data set. Again, it says including but not limited to. In the example, if maybe not exactly what the creation of synthetic data set is, it's very analogous. It's using a real data set to create another data set that may be free or outside the scope of HIPAA. So again, and because it says not limited to. I think there's a very strong case that the creation of synthetic data should fall within this exception as well. So again, I think there's a very strong case to be made that this is not, that the restrictions in HIPAA and the restrictions around getting authorization by the patient should not apply to the creation of synthetic data. So under HIPAA, like other privacy laws, both GDPR and CCPA that we've talked about, there is some regulation around sharing data with service providers. In the HIPAA context, that's typically referred to as a business associate, an entity that is providing a service on behalf of an entity that's covered under HIPAA, a covered entity, a hospital, a doctor's office, etc., would be a business associate. And data can be shared with business associates if there's a contract in place or a similar arrangement that specifies the nature of the service, describes the permitted and required uses of the protected health information by the business associate, and provides assurances that the business associate will appropriately protect the privacy and security of the PHI, protect the protected health information. So, like CCPA, like GDPR, there needs to be a contract in place. The contract needs to specify the services, and it needs to provide appropriate assurances that the data will be protected. Business associates under HIPAA are also directly subject to the security rules and certain aspects of the privacy rules. So business associates are beyond the contractual requirements, have direct obligation under HIPAA to adopt appropriate security measures to protect the data. But again, as long as there's appropriate contract in place and the business associate, or in this case the service provider that's generating the synthetic data, is meeting its obligations under HIPAA, this sharing is allowed and should be open to publicity. All right, finally, the last question, is this data subject to HIPAA? The short answer is no, it's not. Like in the other two laws that we've looked at, this is not real data about actual individuals, actual patients. It doesn't meet the definitions of individually identifiable health information or protected health information under HIPAA, in that the data is not related to identifiable individuals. So again, like in the other two laws, because this data is about a group, it would fall outside the scope of HIPAA. So with that, I know I ran a couple minutes over. I'll turn it back over to Lucy. I just have some key takeaways, but they're just repeating what we've already talked about. Lucy, I'll turn it back over to you now.
Okay, so we looks like we've lost Lucy for the moment. So I might just bring forward a couple of questions. I've got a question for you, Mike. Is your interpretation of the law different if the data is not just synthesized, but only partially synthesized?
Yes, it would be different.
So sorry about that.
Oh, hey, Lucy. Let me just quickly answer that question, and then we can let you finish up your piece. If the data is only partially synthesized, it would be a somewhat different analysis. We would need to see what data is remaining in the partially synthesized data set, and if there is data in there that is potentially identifiable, we would need to look at that in the same way we would look at more traditional de-identification under these various laws. That's not to say that these couldn't be, that kind of data couldn't be used for the purposes we're talking about. It would just be a somewhat different legal analysis, and we probably wouldn't come to the conclusion at the end of the day, again, depending on the facts of the case and the nature of the data, we may not come to that conclusion that it's outside the scope of the laws, but we may be able to use the data subject to the requirements of those laws. It would just be a slightly different analysis to go through.
All right, great. Thank you very much. Lucy, do you want to kick off on explaining how we actually measure privacy risks with synthetic data?
Yeah, of course. Thanks, Richard, and so sorry for that mix-up there. So in this section, I'll be going through an example of our methodology for assessing the privacy and disclosure risks for synthetic data. So our privacy assurance methodology is built on the shoulders of the definitions I went through in the first section. So our privacy assurance methodology aims to quantify the two key aspects of meaningful identity disclosure. So the risk of assigning identities to synthetic records, and if such a match occurs, whether an adversary is able to learn something new from such a match. Both of these criteria must be met for a meaningful identity disclosure to occur. So considering the first element of this privacy assurance, we need to be able to quantify whether or not an adversary is able to make a match between a real identity in a population and a synthetic sample. So for assessing the risk of this kind of matching, we need to consider both the risk of matching an individual in the population to the synthetic sample and the risk of matching an individual in the synthetic sample to the real population. Now, it's possible a match may occur between the individual in the real population who is not in the real sample. So this may seem counterintuitive, but this still poses a privacy risk. So it's possible that the data in the synthetic sample may match individuals in the real population who are not in the real sample if the model of the real sample used to generate the synthetic data was representative of the real population. So when assessing the ability to match real identities to synthetic records, it's important to consider matches from either direction. So the second aspect of meaningful identity disclosure is, given that a match has occurred, are we able to learn something new about that real individual? So we need to determine not just if you're able to learn something new, but if that is something meaningful that you've learned. So in this situation, we can summarize the ability to learn something new by using a 2x2 table of two sets of criteria. So first of all, we need to consider how unique or how unusual the individual in the real dataset is relative to others in the real dataset. Secondly, we need to quantify how similar the matching synthetic record is to the real observation. So going through these outcomes clockwise from the bottom right. The bottom right panel is the situation where the real individual is an outlier in the real data, and the matching synthetic record is not so similar to the real record. In this situation, the risk of meaningful identity disclosure is quite low. In the bottom left, if the real individual is similar to others in the real data set, and the matching synthetic record is not so similar to the real record, then again, the risk of meaningful identity disclosure is low. In the top left, if the real individual is quite similar to others in the real data, and the matching synthetic record is quite similar to the real record, then the risk of meaningful identity disclosure is again low, as in this situation, even though we are able to accurately learn something new about the real individual, what we learn is relatively unexpected, so we wouldn't consider this to be meaningful. Lastly, in the top right, if the real individual is an outlier or is unusual in the real data, and the matching synthetic record is quite similar to the real record, then the risk of meaningful identity disclosure is high, as we are able to accurately learn something new about the real record from the synthetic record, and what we learn is unexpected and thus meaningful. So these are the kind of 4 different options or scenarios for if a match has occurred between a real identity and a synthetic record, what happens in terms of being able to learn something new. This is the second criteria of a meaningful identity disclosure. So our methodology allows us to empirically assess the likelihood that one of these 2 directions of attack is successful, thus leading to a meaningful identity disclosure. So we've done experiments using various clinical trial data sets, and we've seen that the probability of meaningful identity disclosure is very small, and is generally lower than the accepted threshold for identity disclosure. By typical threshold, I mean the value of 0.09 that is used by the EMA and Health Canada, and our results have shown the risk of meaningful identity disclosure has been well below this threshold. We'll be presenting more of these findings in papers and subsequent webinars, so if you're interested in learning more, please keep in touch by joining our mailing list or reaching out directly. In this webinar, we want to provide a more comprehensive overview, especially regarding where synthetic data fits in current regulations, but more technical results will be presented in subsequent papers and webinars. So just to reiterate, we at Replica Analytics have a comprehensive methodology for assessing the risk of meaningful identity disclosure. This methodology can be applied to data we synthesize or data that has been synthesized externally. This assessment provides robust evidence that synthetic data can be used to effectively manage privacy risks in the form of meaningful identity disclosure and ensures that the generating model has not overfit the real data. So that's all from me. So I'll pass things back to Richard to moderate a brief Q&A session. As I mentioned at the beginning, my contact information will be up at the end. So don't hesitate to reach out if you have additional questions that come to you afterwards or if you're interested in discussing potential demos. Thank you very much.
Okay, thank you very much, Lucy. So if we have just a few minutes for questions, so if you would like to ask a question, use the chat within the Zoom application and we'll try and fit in as many as we can. I do have one question for Lucy, however, right now, which is, are the disclosure risks different for different types of data, the different data types, let's say?
Yes, so the disclosure risk is definitely a function of the original data set. So if you have an original data set where you have a very heterogeneous population where many individuals or records in the data set don't look like other records, so you have a high degree of unusual records in your data set, that makes it more likely that you're going to have privacy concerns in your synthetic data set, because each synthetic record is more likely to be less similar or more unique, which means that the privacy risks will be higher.
Okay, thank you very much. This is probably one for Mike. Do you have any thoughts on privacy regulations regarding synthetic data in other regions, either existing regulations or upcoming ones, for example, Japan or Canada?
Yeah, and I haven't done detailed analyses under those two jurisdictions or many of the laws that are on the books today and in the pipeline right now, but I would expect the results to be fairly similar. I mean, almost every privacy law contemplates the idea of sharing data with service providers. Almost every privacy law, although it may regulate that initial use of the real data set, I'm not aware of any privacy laws that would prohibit it. There may be questions about concepts similar to the legal basis under GDPR and what you would need to do to address that. But again, I'm not aware of any privacy laws out there that would throw up significant barriers to the issues that we've discussed. And in fact, many would actually encourage this in kind of the same ways that they encourage de-identification and other risk mitigation strategies, because this is, at the end of the day, one of the strategies that can address the concerns that these privacy laws are really getting after, and that is protecting data, protecting the privacy of individuals, while still enabling data to be useful.
Okay, thank you very much, Mike. Now, we've had 3 further questions, all of which look very pertinent. However, I have been asked to keep this to exactly 1 hour. So what will happen is we will respond to those further questions by email. So it just remains for me to say that the information that you will receive is the materials from this webinar, and then we will send you additional reports on the topic, answering your questions, the Accelerating AI using Synthetic Data report, other technical reports on privacy assurance, and an invitation to our next webinar, which will be in the new year. And so if you're interested in following up, next steps would be to contact us at info@replicaanalytics.com. And because of privacy laws, which of course is our business, we will have to ask you to opt in to receive more information from us. So it's important, if you wish to stay in contact, that you do opt in to receive our communications. Okay, and on that note, I'd just like to say thank you very much from our speakers.